what is there left for the states to assume under Section 404 that isn't already outside of the purview of Section 404? I raise it as an actual question because I don't think there's much.
Justice Alito, as I read his opinion, uses these canons of construction not to attack Justice Kavanaugh's test, but rather to attack the EPA's significant nexus test.
What would you say to folks at EPA who would say, what's the point? Whatever we do is going to just end up in court, and we're not going to get any difference anyway.
If significant nexus is dead and that undermines the use of significant nexus throughout the rule, then I think you end up with a bit of a shell that doesn't really have a purpose.
If I could sort of tangentially answer that, Jeff, I think part of the attraction to the majority of the rule they came up with is their hope that it will obviate the need for the JD process.
What do folks think? Do folks think that the Sackett II opinion is going to affect EPA and the Corps' enthusiasm about authorizing states to regulate?
And to be fair, it made a lot of sense in Florida because telling the difference between navigable and non-navigable in much of Florida is really hard to begin with. I mean, there's a lot of admiralty cases on that point.
We'll likely see arguments made that, all right, well, under Sackett II, this wetland may not be regulable anymore, but it's pretty likely that this pollutant is going to flow downstream at some point into a regulated water, and therefore there's still liability.